The type of property most frequently acquired by spouses during marriage is financial compensation for labor. Recall that under the community property presumption, property acquired by either spouse during marriage is presumed to be community property. Consequently, as a general rule, compensation for either spouse's expenditure of effort, time, and skill during marriage is characterized as community property. California statutes and case law elaborate on that general rule, providing additional guidelines for common forms of work-related compensation, including wages, tips, stock options, retirement benefits, and workers' compensation. Wages refer to an employer's compensation to an employee for services rendered. Wages earned by either spouse during marriage are community property. Vacation pay and bonuses stemming from employment are also community property. And recall that property's characterization at acquisition continues to apply even if the property changes form or identity. Consequently, assets purchased using wages are also community property. The characterization of a spouse's wages as community property applies even if the other spouse earns significantly less or is unemployed. The higher-earning spouse won't be entitled to a greater share of community property upon the marriage's dissolution. As an example, imagine that for the duration of a couple's marriage, the wife is a highly paid property developer and the husband is a part-time preschool teacher. Both spouses' wages during marriage are community property, as are items purchased using those wages. If the spouses divorce, the community property income and assets are equally divisible between them. The wife isn't entitled to a greater share because of her higher-paying employment.